Yes, sir.
So, welcome everyone on behalf of Legal Specs and myself to the seventh session as part of this M&A course. Today, we again, unfortunately, do not have a very lengthy topic to discuss and, come to perhaps informed solutions on. It is a very simple concept of post-merger integration and associated challenges. So without further ado, let's quickly get into understanding the legal and operational issues that arise in post-merger scenarios. So as the name suggests, post-merger integration is the phase that follows the closing of a merger or acquisition, excuse me, and involves combining the operations, systems, people, and cultures of the two different organizations, or if there are more than two, of course, those respective organizations. So despite the strategic intent behind most mergers, post-merger integration is the most challenging phase due to complex legal, operational, as well as human factors. So let's quickly understand, excuse me, what the legal challenges are, excuse me, are primarily. So firstly, as you all might have seen, a lot of regulatory compliance and approvals, associated approvals, excuse me, are required to be obtained. So primarily, mergers may require approval from regulatory authorities like CCI, SEBI, RBI, and sector-specific regulators, respectively, if they are prospectively violating antitrust laws or they're creating adverse appreciable effect on competition, or if they're lifted, if they're listed entities, or if there's any FDI or FEMA compliance, or if there might be any concern associated with insurance, where you would go to the IRDAI. Excuse me, I'm not keeping very well. Please bear with me. Or if there's any company that is associated with the telecom sector, in which case you would go to the TRI, etc. So missteps in obtaining or complying with these approvals can delay or invalidate the integration. Second is the contractual and liability risks. So legacy contracts may not be easily transferable or enforceable post-merger. So certain contracts can change, certain contracts contain change of control clauses which require counterparty consent. Also, successor liability can expose the merged entity to inherited liabilities, lawsuits, or compliance failures of the target. The third is your labor and employment law issues, which basically includes integration of workforces, which will involve harmonizing employment terms, severance obligations, retirement benefits, while complying with the applicable labor laws. So redundancies or rule duplications may require layoffs, which trigger notice and compensation under the Industrial Disputes Act 1947 and other relevant statutes, of course. If you recall correctly, it's Section 25FF of the Industrial Disputes Act of 1947. I mean, provided, of course, the Industrial Disputes Act 1947 applies. This is the workman threshold fulfillment, and the the engaged workforce being categorized as workmen. I mean, vice versa. I think you would say the latter first, and then you would say the former. Because you think you would first identify who class, like if there's a classification of certain part of the workforce as workmen, and then you would see if you would like, I mean, if the workman or workers threshold has been fulfilled for applicability of the Industrial Disputes Act of 1947. Then comes your concerns associated with consolidation of intellectual property. So basically, merging intellectual property assets requires due diligence to verify ownership, ensure non-infringement, and reassignment of rights. So overlapping trademarks or how do I put this? Unregistered rights as such can create legal exposure. So licensing agreements may also need renegotiation or termination. So then comes data protection and privacy compliance. So with the rise of data protection regimes like the DPDPA and GDPR, post-merger integration must ensure lawful transfer of personal data, revise privacy policies, and reobtain consent where necessary. So mishandling consumer data can result in penalties and reputational damage. Then comes your tax structuring and disputes, which wherein we have to understand that mergers can trigger tax consequences, such as capital gains, minimum alternate tax, or carry forward limitations of losses under sections 72A or 47 of the Income Tax Act of 1961. So disputes may arise over legacy tax positions of the target entity, pending litigation, or differing interpretations by the tax authorities. Then comes your corporate governance and board compositions. Basically, post-merger, changes in shareholding and control may necessitate reconstitution of the board of directors, management committees, and amendment of charter documents. So conflicts may arise, excuse me, regarding representation rights, decision-making authority, and corporate governance standards. Then comes the operational challenges, which is also a very crucial part. So the first is merely cultural integration and change in management. Because I think if you see, cultural misalignment is one of the top causes of post-merger failures. Because differing organizational values, leadership styles, and communication norms often lead to employee dissatisfaction, productivity drops, and attrition. So managing egos and legal hierarchies is critical, but often an overlooked challenge. Excuse me. Really unwell. I'm really sorry about that. So then comes IT systems integration, IT and systems integration. So basically unifying disparate IT systems, databases, ERP platforms, and cybersecurity protocols is both technically complex and costly. So downtime, data loss, or incompatibility during this process can disrupt operations. Further, I think if you think standardizing digital processes requires clear governance and strategic investment. So this is again another operational challenge that will arise. Then comes your operational redundancy and streamlining. Mergers, if you understand, usually lead to duplicate functions, like two HR or finance departments, which require rationalization. Like you can't have the merging entities having their own HR or finance departments, right? You need to have one unified department. So the issue that arises in this regard is the integration of standard operating procedures, reporting lines, and performance management frameworks have to be done without disrupting day-to-day operations, and it is a major balancing act. Then comes your issues with communication and stakeholder alignment. So unclear or excuse me for that again. Unclear or delayed communication can create uncertainty among employees, customers, and investors. So change management and trust building depend heavily on transparent, consistent messaging about vision, roles, and expectations during the PMI phase. Then comes your supply chain and vendor realignment. So basically, one second. So basically, clients may be uncertain about service continuity, relationship management, product strategy, etc. After the merger, and associated with that come your vendors and supply chain partners, which may differ across merging entities. So while the former is creating an issue with regard to customer intention and brand integration, the latter is creating an issue with regard to supply chain and vendor realignment. So, I mean, before I discuss the former, let me discuss the latter first. Because consolidating procurement, renegotiating contracts, and managing supplier expectations without disrupting delivery schedule is logistically and contractually challenging, which is what has to be ensured, which is what has to be done seamlessly so that the resultant entity does not have any issues. Uh, Then comes, as far as customer retention and brand integration goes, the brand requisitioning or consolidation can lead to customer churn if it is not managed delicately, especially where customer loyalty is tied to the legacy of the identity. I'm sorry, yeah. So, I'm sorry. So sorry for that. So I think I mean, managing your customer base and indicating the value of the product or services of the resultant entity so created, and ensuring that the target customer base is definitely hit upon before you reach out to prospective customers is very important from an operational standpoint. Then comes your performance monitoring and KPI alignment. By KPI, I mean key performance indicators. So just understand here that the merged entity must define new key performance indicators, benchmarks, and success metrics across business functions. Misalignment in operational goals and perhaps lack of unified reporting can lead to internal inefficiencies. Let me quickly go to the next slide. This I think we have already discussed in our previous classes. And if you want a quick rundown, you can just like take a look at this. But yeah, let me quickly come to the second part of the first topic for today, which is like a specific integration of legal issues, which I will discuss employment law issues, transfer of liabilities, compliance considerations in post-merger integration. So from an employment law perspective, understand that post-merger workforce integration is legally and operationally complex. So Indian labor laws fragmented across central and state legislation require specific attention to multiple things. First of which is continuity of employment. So in asset purchases, more specifically, employees are not automatically transferred unless new contracts are executed. So this may require retrenchment and therefore fresh hiring, triggering notice, severance pay, and compliance with Section 25 of the Industrial Disputes Act of 1947. Okay, I think you've had sufficient time to take a look. I will come back to it again if you want me to. Let me quickly go back to the previous slide. Then comes the indication that in share purchases or mergers via court, the legal entity remains the same, so employees continue without interruption. However, contractual renegotiation may still be required if roles or locations change. Then comes your consent and communication. Understand that transparent communication and consent are vital, especially when changes in terms of employment are anticipated. And lack of proper communication can lead to attrition, union unrest, or even litigation under unfair labor practices. Excuse me. Then comes your transfer of employment benefits, wherein you need to understand that your employees' provident fund, gratuity, and leave encashment liabilities transfer to the acquiring entity. So if the acquirer has a different benefit structure, like performance bonuses or stock options, harmonizing without reducing benefits is key to avoid breach of contract claims. Like maybe the resulting entity would not, I mean, basis the negotiations, the resultant entity so created would probably not be following a policy of giving employee stock option plans in a certain number of years to employees, and maybe in one of the entities that are involved in the merger, employees have been given this employment stock option plans. I mean, a little earlier on in the career than what has been negotiated as part of the merger. So while you might be while you might be how do I put this? While you might be depriving these employees of the employee stock option plans that they are in possession of, you make sure that they get some sort of monetary compensation, or get some incentive at a futuristic point in time, a reasonably futuristic point in time, if they are agreeable to it. Once the new entity is formed and they are and they're taken in as part of the employment structure or the workforce of the resultant entity. So that's basically what this indicates when I say harmonizing without reducing benefits. Then comes your trade unions and industrial relations. So in unionized setups, any change in working conditions, like I mean, like to any extent for that matter, may necessitate negotiation with the union, and failure to consult unions can lead to strikes or action before the labor tribunals. And this is a new, this unfortunately was not in the Trade Unions Act or even under the Industrial Disputes Act of 1947. This has come into place basis the Industrial Relations Code of 2020, which is one of the new labor codes, and this is not in effect yet, unfortunately. Then comes your employee termination, which basically indicates that retrenchment must comply with statutory notice, severance, and in some cases prior permission from the labor authorities. And only if greater than more than 100 employees are affected in certain industries. Perhaps what can now be understood in addition to that is, in case of wrongful termination, reinstatement claims or penalties under various labor enactments can be triggered. Then comes your transfer of liabilities. So M&A transactions must address both known and contingent liabilities, and the mode of acquisition plays a crucial role. We've discussed this in significant detail in a number of previous sessions, but let me just quickly take you through the same. Right? First is your asset sale versus slump sale versus share sale. So in asset purchase, the buyer can selectively assume liabilities. However, under successor liability doctrines, especially tax, environmental, and labor laws, some obligations may still pass. Then comes your slump sale, which is under Section 242C of the Income Tax Act, wherein an undertaking is transferred as a going concern, meaning all assets and liabilities, including employment liabilities, pass. Then comes your share purchase, wherein all liabilities of the company continue as is, and this includes contractual liabilities, tax dues, and pending litigations. So what are the tax liabilities exactly? So unpaid tax dues and ongoing assessments become the buyer's problem in a share deal. So indemnities and escrows are commonly used to mitigate this. And in an asset deal, certain indirect taxes like GST are exempted, but input credit and historical liabilities need verification. Then comes your environmental and regulatory liabilities. Like under Indian law, particularly Environment Protection Act of 1986, liabilities arising from past contamination or violations may flow to the buyer, especially if the same undertaking is continued. Then comes your contingent and litigation liabilities, wherein legal due diligence must identify ongoing cases, labor disputes, contract claims, regulatory notices, etc. And indemnity clauses and insurance are also in place, such as warranty and indemnity insurance, and representations and critical risk mitigation tools are also put in place from time to time. That was a quick rundown of the legal considerations. Before we get into the compliance considerations, I'd like to know if there are any questions. Okay, I take that as none. Let's proceed. So then comes your compliance considerations. So here, understand that the first thing is your statutory registrations and filings. So apart from your CCI and your SEBI and RBI filings, regulatory filings, you will also have the need to file for a new PAN, TAN, GST registrations, and also registrations under the Shops and Establishments Act of the respective state, and also registrations before the EPFO and the ESIC, which are the authorities for EPF and ESI respectively, among many others. So this must definitely be reflected there. And also you have to intimate the registrar of companies under the Companies Act of 2013 and SEBI for listed companies. For competition law, again, threshold, CCI, Competition Act 2002. Labor law, you also, I mean, your Shops and Establishments Act will stand. And apart from that, if there are any like HR policies in place and if there are any standing orders in place, then you also have to apply for that. I mean, you also have to ensure compliance with that if those standing orders are legally obtained basis the procedure stipulated under the Industrial Employment Standing Orders Act of 1946. Then comes your foreign exchange and sectoral laws. So if the merger involves foreign investment, as indicated, FEMA compliance, etc., your RBI, RBI registrations are compulsory, and of course your sector-specific approvals, as indicated. Sorry if it's getting too repetitive. Your insurance under IRDAI, banking from RBI, and telecom from Department of Telecommunications, and TRAI wherever necessary, may be necessary before the merger takes effect. One more thing that you'd want to note here is of a consideration for anti-corruption and anti-bribery, where the acquirer becomes liable for past violations under laws like Prevention of Corruption Act, foreign laws such as FCPA and the UK Bribery Act, especially in cross-border M&A. So you have to obtain requisite representations and warranties accordingly, as has been explained in the previous classes. So how is it to be done is the next big question. We don't have a slide for this, unfortunately, because I really think that this is more like a strategic discussion, because you know what exactly is going wrong. So you just want to then understand on the things that have to be done right. So you can just reflect on whatever we've discussed now, and I'll be giving you strategies to ensure that your compliances go right. So let's understand this in two parts. Let's understand it first as a pre-merger compliance, right? And if necessitated, post-merger compliances, as may be there from time to time. So your first pre-merger compliance is notification to the Competition Commission of India. So like under this, let's understand the triggering thresholds for combination notification. Good. Yeah, this slide is there. So a transaction is treated as a combination if it meets certain assets or turnover thresholds, which has been prescribed under sections 5 or 6 of the Competition 5 and 6 of the Competition Act of 2002, and it is updated periodically. So, for example, combined assets in India are if they're greater than 2,000 rupees, 2,000 crore, or turnover, which is in turn rated greater than 6,000 crore rupees. And on group level asset or turnover thresholds, you look at it from a global context. So a failure to notify a combination or closing a deal without CCI clearance, which is known as gun jumping, can lead to penalties under Section 43A, and this penalty can be up to 1% of the total turnover or assets. So what are the types of combinations that are covered? The first is acquisitions, second is mergers or amalgamations, the third is global mergers or with Indian nexus, which may also require notification to CCI. Then comes your Form 1 and Form 2 filings. Form 1 is a short filing for combinations unlikely to cause competition concerns. Form 2 is a more detailed filing for complex or high-stake combinations like horizontal overlaps or vertical integration. So what does the CCI do then? The CCI, once notified, conducts a phase 1 or a phase 2 review depending on the perceived risk. So in case of horizontal combinations, these involve competitors and raise red flags if the post-merger market share is high or if barriers to the entry are significant. So the CCI will assess three things. First, market share or current concentration index. Second is potential for price fixing and coordinated behavior. And the third is loss of innovation or consumer choice. Then comes your vertical combinations. So these involve entries at different stages of the supply chain. And the concern here is foreclosure of market access, preferential treatment, or denial of inputs to rivals. Then comes your conglomerate combinations, generally seen as less risky, but CCI may scrutinize if the combination creates portfolio effects or strengthens dominant positions. Then comes your assessment factors under Section 24. The CCI evaluates factors such as extent of barriers to entry, I'm really sorry. I've been very unwell today throughout this class. I'll make sure I'm in a better position by the next class. Then comes your level of innovation. Then comes your, excuse me, nature and extent of vertical integration. And then comes your relative advantages to the consumers. So what are the remedies, if any? So if the CCI identifies after the filings that there's a potential adverse appreciable effect to competition, it may propose structural remedies like divestiture of overlapping business units. It may suggest behavioral remedies like non-exclusivity clauses, firewall obligations, access commitments, etc. And it may reject the combinations if remedies are not acceptable. So the merging parties may often, how do I put this? May also offer voluntary okay. The merging parties may also offer voluntary modifications, which is provided for under Regulation 19(2) of the Competition Act of 2002 to address CCI concerns during the review phase. So then comes your post-merger obligations and monitoring, which is the second part. So even after approval, certain combinations may be subject to ongoing commitments like periodic compliance reports, monitoring trustee commit appointments in case of divestiture, and prohibition from reacquiring divested assets for a specified period. So if the CCI later finds that misleading or false information was provided, it may reopen the case under Section 21 of the Competition Act of 2002 within 1 year from the date of combination. Then comes your global merger control and cross-jurisdictional filings. So for international M&A deals, parties must assess multi-jurisdictional competition filings like EU, US FTC or DOJ, like the Federal Trade Commission or the Department of Justice. Then China's SAMR. Then comes your global gun jumping concerns, which will necessitate careful closing sequencing and interagency coordination. Yeah, then of course, the Indian CCI often collaborates with foreign regulators through international cooperation frameworks. Then, what exactly can be your internal compliances during the post-merger integration? So, to stay compliant during your post-merger integration phase, one should segregate sensitive business information until clearance is received and basically clean teams and non-disclosure agreements are in place. Then you need to avoid joint marketing, pricing, or customer discussions pre-clearance. Then you need to train your PMI post-merger integration teams on competition law restrictions, and you also need to implement a competition compliance program to detect early risks. Then, what are the special concerns in Indian markets? So, first is your digital markets. So, with recent focus on big tech, the CCI is increasingly reviewing deals involving data, platform power, and algorithmic collusion. Then comes your common directors or interlocks based risk. So director interlocks or common shareholding post merger can raise antitrust concerns under Section 3 of the anti-competitive which is for anti-competitive agreements. Then comes your exemptions, wherein certain transactions like intra-group restructuring, minority acquisitions below thresholds may qualify for CCI exemptions under the combination regulations. Uh, we then come to the last part of today's lecture, which are the lessons to be taken from failed M&A deals. But before that, I'd like to know if there are any questions. Or if you want me to repeat anything, that's also cool. Toshika, I will answer your question towards the end of the class. I'm sorry, I just saw it because I was in a flow. I couldn't probably hear the notifications on. I'll answer your question towards the end of the class. Anyone else? Okay. So the first case study is the Daimler-Benz and Chrysler merger of 1998, which is a deal of $36 billion, and the nature was of a cross-border merger of equals. So what went wrong is, first there was a cultural clash, that is Daimler's his hierarchical, precision-driven German culture clashed with the Chrysler's fast-paced, risk-tolerant American style. So, and like that was the cultural clash. Okay, I see your question. Oh yeah, sure, I'll do that. Uh, the PPTs will be shared. Muskan, right? Yeah. Then comes your misalignment of strategic objectives in this case, where Daimler, I'm sorry if I'm not, I don't know if I'm pronouncing that correctly, but yeah, Daimler aimed for premium car markets, while Chrysler was focused on cost-effective vehicles. Then came your leadership turmoil because of difference in management styles, which led to executive turnover and internal resistance. Then came your lack of synergy realization, wherein there were no operational or technological benefits which were effectively leveraged. So the lessons that could be respectively learned from this is that cultural compatibility is as critical as financial logic. Integration planning must be clear before the deal closes, and the merger of equals model often fails without aligned vision and governance clarity. The second example that we'll take for today is a very famous Indian example, which is that of Snapdeal and Flipkart from back in 2017, which was a deal of perhaps US dollars 950 million. Um, So it was a potential acquisition of Snapdeal by Flipkart, which were two Indian e-commerce giants back then. Snapdeal is, I think, out of picture now. I think people hardly use it. So what happened? What went wrong? Even I think Flipkart, I think Amazon is like, I am probably not authorized to make these statements, but like I'd like to indicate this as an opinion. I think Flipkart's e-commerce business has been completely taken over by Amazon. I think people don't rely on Flipkart anymore, unfortunately. So what happened first is that there was a shareholder conflict wherein a key investor, which was SoftBank, pushed for the deal, but Snapdeal's founders and other shareholders resisted. Then came valuation disputes because of Snapdeal's internal valuation expectations, which clashed with market realities. Then came your brand identity concerns, wherein Snapdeal's founders feared a complete loss of independence and brand. And then came your regulatory complexity, because integration could have raised competition concerns as both players had major market shares. Now, the lessons that can be learned from this is that alignment among all shareholders is essential, especially in venture capital heavy companies. The founder's vision and control preferences can override investor interests, and market consolidation must be approached with caution in a highly regulated digital sector. Then comes the third example for today, which is Reliance Industries and Future Group, which I think was which I think was a significant problem, if I could so as to put it, between 2020 and 2022, which was a deal value of I think INR 24,730 crores, which was acquisition of retail, logistics, and warehousing business of Future Group by Reliance Retail. So what went wrong is firstly legal disputes, because Amazon, which was a stakeholder in future apologies, invoked its, correct myself, invoked its, what did it invoke? Yeah, I think it. I mean, I'm sure it had invoked its rights under a shareholder agreement and obtained an emergency arbitration award from SIAC, like the Singapore International Arbitration Center. So, regulatory and judicial delays was another cause that came with it, because in the Indian Courts and Competition Commission of India were involved and they delayed the process. And there was a lot of contractual oversight because Future Group overlooked the non-compete and right of first refusal clauses in its Amazon agreement. The lessons learned here must be that due diligence must include a detailed review of all existing shareholder and investment agreements. International arbitration clauses must be anticipated and planned for, and pre-existing contractual restrictions can derail even fully negotiated domestic acquisitions. Another example that we'll be taking again from today is the HDFC Bank and Centurion Bank of Punjab from merger example from 2008. I'm sorry, acquisition example from 2008. This was, I think, of a deal value of rupees 9,510 crores. And the nature was acquisition of retail and branch expansion. So what went wrong here is that though the merger was financially and strategically successful overall, there were significant post-merger operational disruptions. So first was employee dissatisfaction due to changes in incentives. Uh, uh, so your employee dissatisfaction due to changes in incentive structures and job roles was first, and second was customer iteration in regions where the CBOP had a loyalty-based banking. Then comes, I'm so sorry. Let's quickly take a look at what the lessons in this were. So first is that employee integration and stakeholder communication must be managed with empathy and clarity, and your customer experience continuity must be prioritized during operational migration. And also that HR policies must be harmonized post merger, and it requires more than just one policy, more than just a policy revision. It needs cultural alignment. The last example that we'll be taking for today is the Jet Airways and Air Sahara acquisition from 2007, which is a deal value of perhaps 1,450 crores. Uh, what went wrong here was that first there was an overvaluation. Basically, Jet significantly overpaid for Sahara, which had legacy issues. Uh, excuse me. uh, which had legacy issues and financial distress. Second, there was a poor operational fit, wherein there were differences in fleet types, crew policies, and route strategies were not reconciled. The third is that there was a brand integration confusion. Basically, initial rebranding to Jetlight confused customers and diluted brand value. So what were the lessons learned? So first is that strategic acquisitions must be preceded by realistic valuations, especially in distressed asset cases. Second is that operational integration of airlines, like crew systems and standard operating procedures is highly complex and must be faced carefully. And third is that the brand dilution can be reversed. I'm sorry. I apologize. I correct myself. If the intended value of a merger is not executed with clarity and consistency. So let's quickly take a look at the lessons that one can take for successful post-merger integration. Uh, So firstly, as far as cultural integration is concerned, conduct cultural due diligence, not just financial and legal. For stakeholder alignment, I'm sorry, or shareholder alignment, ensure that there is an early alignment with all shareholders and any other requisite stakeholders. Let's actually change this. Actually, no, let's restrict it to shareholders. I will deal with other stakeholders subsequently. Let's consider shareholder alignment, and like you need to ensure that early alignment with all shareholders is in place so as to avoid post-deal derailment. Then comes regulatory awareness. You need to understand sector-specific regulations, foreign investment laws, and antitrust frameworks. Then comes due diligence. Basically, there has to be a deep dive into contractual obligations, litigation exposure, and contingent liabilities. Uh, Most importantly, There has to be a valuation discipline. Basically, you need to avoid paying premiums based on speculative synergies, and valuation must reflect realistic risk. Lastly, when it comes to integration planning, understand that integration should start as early as the negotiation stage with dedicated terms and governance. That brings us to the end of today's session. I'd like to take questions if any. It's a pretty small topic, so there's not really much to say also. I tried to be as verbose as possible, but and it just looks like we have some time left. But are there any questions? Okay, I take that as none. I hand it over to you, representative from Legal Specs.
Yes, sir. Thank you so much. Just one second.